Hey guys, welcome back to the channel. In today's video, we're revisiting a familiar face, Leonard Blatt, a self-proclaimed sovereign citizen I've covered a few times before. This time, he's appearing for a pretrial conference, and as expected, he dives straight into his usual sovereign citizen nonsense. But things don't go quite his way, as the judge quickly steps in and puts him firmly in his place. Let's get into it.
That just doesn't change the court date. It does change. Mr. Blatt, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
First of all, the state has received a supplemental report and is prepared to establish probable cause at this time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pretrial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one. Which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it M-E-Y-E-R?
Yes.
And the prosecutor's name, again, is...
Last name is Kidmacher.
Okay. And first name?
It's Gabby.
Okay. And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And the bond is equal to the insurance that a driver would need to have.
You can come up with as many analogies as you like, but that doesn't make them true. The law is very clear. There are statutes requiring drivers to carry a valid license and proof of insurance while operating a vehicle. However, there are no such statutes that require court officials, including judges, to carry their oath of office or bond with them at all times.
So I do have an oath of office. It's good. The auditor's office. If you want to go there and get it, you can certainly look at it. But like I said, I don't carry it with me. I don't have it on the. I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't. We're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, but it really doesn't. Right now, you're the one charged with driving with license suspended in the third degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now,
Yeah.
at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
Yeah, I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
I don't know about the franchise aspect of it, but it is a municipal case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's a flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes.
For certain crimes, yes, the state takes responsibility. For others, no. Some violations, like murder, fall under state law and are prosecuted by the state. Meanwhile, lesser offenses, such as parking violations, are typically handled by the city. But that doesn't mean the state has somehow franchised the city to enforce its own laws. Rather, each operates within its respective legal authority.
So
I don't agree with your terminology there in terms of what they franchise. Tumwater is a municipality. They have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this. Not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the third degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies obviously would be under the revised code of Washington, and that would go to Superior Court. This is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. And don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset
Yes.
about being called a criminal. I'm not a criminal, and I want to clear my name. Believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the third degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
Now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. A passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support the presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
I hate to break it to you, but your charges aren't going to be dismissed just because you have a terrible understanding of the law. It's also been a while since the sovereign citizen has pulled out Black's Law Dictionary, which, as the name suggests, is just that, a dictionary. What it definitely isn't, however, is a substitute for the classic practicing law for dummies.
No, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the Revised Code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all those things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know that anything I say can be used against me in court. I'm fully aware of that.
So hang on just a second. Well, it can, but you shouldn't admit that. If by traveling you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide.
Okay, so hang on just a minute. Before we get there, can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, I've went back to this before. Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions, and that means if you wish to go to trial, you can do that. And we can have a different conversation about your ability to represent yourself, which you certainly have a right to do, but I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you, but when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rolls within the county, and it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7,
Yeah,
right?
typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judge is to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to deny that. That's the first thing I would tell the jury if it goes to trial.
Admitting to the jury that you actually committed the crime you're being accused of is certainly a bold legal strategy. Bold, but completely ineffective. Still, if that's the path you want to take, don't let me be the one to stop you from trying.
Okay.
And I'm going to bring up to the jury the issues of law. My question to the court is how would
here in a second, I'm going to stop you for a second, because you're very wrong about something. Okay, you are very wrong about something. The jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court, and that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. Some of these legal issues you wish to argue, you might not be able to do that. Probably not, because that's just what the law is. And I know what the law is based on my experience, and I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave, because it's at 2:30. And we have some other people coming on at 2:30. We're going to take care of those cases, and then I'll come back and speak with you some more. All right?
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts, and basically juries have been neutered since the rules of evidence have been implemented in the 1936. But this jury is going to hear the law as well as the facts, and I'm just curious. I would like to know how the judge would, how the court would stop me from communicating with the jury.
Well, that one's simple. It's called contempt of court. If a judge tells you not to pursue a strategy that's already been ruled on, and you go ahead with it anyway, say, by trying to redefine what the word driver means, the judge has every right to step in. He can halt the trial, hold you in contempt, send you to jail for a bit, and then resume the trial once you finish serving your time.
Okay, so Mr. Blatt, I'll come back to you. So I think when last we talked, you said you wanted a trial by jury or a jury trial. To me, again, that's...
No, I did not say that. I want to be left alone. That's what I said.
Okay. Well, again, that's what everybody wants. So do I. But nonetheless, where you're at right now, you're charged with driving with license suspended in the 3rd degree. And you had made the distinction, I think you had, and correct me if I'm wrong, I don't mean to misstate things. you were making a distinction between jury trial and trial by jury, and I'm not sure exactly what you meant by that.
Well, a trial by jury, which is what we used to have before the passage of the 19th Amendment, when women got the right to vote and therefore got the right to sit on juries. Juries had the right to investigate the crime scene, to consider the law, to nullify. Basically, it was a trial by jury. Now it's a jury trial where the jury's neutered. There's only 6 of them. They're cut in half, and they're not allowed to. They're scurried out of the courtroom every time there's important adult issues to consider, like children, and that's just nothing. That's not a trial by jury. But anyway, I have a dispositive motion right now that might settle everything here.
Okay, we'll set that for a motion hearing, though. We do those on Monday morning. Did you file it in writing?
I'd like to do that. I prefer everything to be in writing. So can we schedule a motions hearing?
We certainly can. But before we do that, I want to talk to you about, it again appears to me, well, we're going to do a couple of things. First of all, I am going to find, based on, there's a police report filed in sector. Based on that, I'm going to find that probable cause exists. And then we're going to set conditions of release, which basically are make all your court dates, don't drive without license or insurance, and don't have any other criminal law violations. Based on our conversation thus far, it appears to me that you wish to represent yourself at trial. Is that true?
I don't understand that terminology. I am myself, so why would I want to represent myself? Only corporations need to be represented because they can't speak for themselves in court. I'm not a corporation. I'm a human being.
So you wish to proceed to trial without a lawyer?
No, I wish to be left alone. That's my only wish.
But yeah, that's true. But that's one that's not going to happen in terms of this case. It is set for trial. The trial will take place. And my question to you is, you have the right to have a lawyer with you during trial. And you also have the right to go it alone, all by yourself. And so, Mike, those are your 2 options. Which of those do you wish to take?
Well, I have some concerns about being represented by an attorney because attorneys in this state are licensed and franchised to make a living in the plaintiff's courtroom only at the pleasure of the plaintiff, right?
You're completely right. What was said made no sense. Just because defense attorneys are licensed by the state doesn't mean they work for it. Licensing only means they're authorized and regulated to practice law. Private defense attorneys represent their clients, not the government. Only public defenders are employed or contracted by the state, and even then, their duty is to defend the accused, not to serve the prosecution's interests.
No.
Well,
I mean, you're under you have a lot of unfortunate and incorrect impressions. You really do. And that's really unfortunate. And I'm trying to, let you know. And again, you're just wrong about a lot of things. And I'm sorry about that.
Does the plaintiff have the power to disbar the attorney if the
No, absolutely not. I don't know why you would think that. That's completely not true.
Well, I personally know attorneys who have been blacklisted because the courts don't like the way they defend clients because they do it too effectively. For example, Lee Eckhart was not disbarred because he never did anything wrong, but he was blacklisted, which means any client he hired automatically lost. And he had to inform each client that wanted to hire him.
I don't know anything about that individual. I don't know anything about that. You're asking me, I guess, in this court, whether, or just generally, whether the plaintiff, in this case would be the prosecutor, has the right to disbar attorneys. And the answer to that is no, they don't.
The plaintiff is the state of Washington because Washington.
Well, the city of Tumwater in this case. Remember, we talked about that.
Yeah, but the city of Tumwater is a subdivision of the state of Washington.
But they can still bring case. So again, what do you want to do for your upcoming trial in terms of an attorney, or have one with you, or go it alone?
I'm not sure I need an attorney at this point because we'll have to see.
So again, that's a binary choice. So then from that, I can tell you you're choosing to go it alone. And have you ever done this before? Have you ever conducted a trial of any sort?
Just look at my record.
That's, again, I can see your record, but none of it tells me whether or not you've done a trial by yourself before. So, Mr. Blatt, have you ever conducted a trial before by yourself?
I didn't come here to answer questions. I'm sorry.
Okay. Okay. So, then I'm going to talk, and then we're going to set a date, and then we'll conclude the hearing.
I need to bring something to your attention, if I may.
I'm sorry?
I need to bring something to your attention. The United States Constitution at Article 1, Section 1 states that when the state is a party, which is this case, excuse me. Let me get my glasses. When the state, it says in all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. This is in the United States Constitution. Now, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary. This is a fundamental principle. When the state is accusing a citizen of a crime against the state can't take the defendant to trial in its own court. That would be a conflict of interest. It has to take it to a neutral court, which is the United States Supreme Court. It says it clearly here at Article 1, Section 1 in the United States Constitution.
You're mistaken about Article 1, Section 1. It has nothing to do with this. The provision you likely meant is Article 3, Section 2, Clause 2. Even then, you're misinterpreting it. When the Constitution says the Supreme Court has original jurisdiction, it means certain cases can be filed directly in the Supreme Court without going through lower courts first. It doesn't mean that if a state is a party, the Supreme Court is automatically the only court with jurisdiction over the matter.
So, again, I'm going to speak for a few minutes, and then I'm going to turn it back to you, and we're going to set a date here. And again, I don't... first of all, this case is headed for trial. And again, it doesn't appear that you're interested in having an attorney appointed to represent you, so you'll be going it alone. When you have the constitutional right to do that, but you need to know that you're not an attorney. Apparently, you have very low opinion of attorneys generally, and a very low opinion of the system itself. Could you tell Mr.
I have no problem with the law.
Hang on, let me finish. I'm not done yet. The city of Tumwater is going to be represented, and I know you don't like that term either, by an attorney. That attorney is trained in the rules of evidence, trained in the rules of procedure, been through trial many times. And again, I don't know whether you have or not. And so they are experienced in the rules of evidence, which is important. You spoke disparagingly of the rules of evidence earlier. And they have training in that, which again is important. And I'm going to assume you don't. And many of the things that you've talked about, you're incorrect on. Unfortunately, you're just incorrect about some things. And so you're going to be at a big disadvantage when you go to trial without an attorney going it alone. Do you understand this?
Isn't it the prosecutor's job to decide whether I'm wrong on issues? You're supposed to be neutral. The prosecutor hasn't even argued against me, and you're already saying that I'm wrong.
No, I'm trying to, believe it or not, and you probably won't. I'm actually trying to help you, let you know that this is just the way things are going. This is the way that this will happen. I'm not siding with the prosecutor. I'm just saying that this is what, and it's not the prosecutor's job really to decide what the prosecutor and defense, they disagree all the time on what the law is or what should be. And then I'm the one who gets to decide one way or the other. But some of the things that you're saying are so outside the norm that I don't need to hear from them. And I'm trying to let you know that what you think is going to happen and what you think the way things work is simply just not correct. And, I'll go back to that fundamental, I can't speak to the way juries were back in the 19th century. I just know how they are now. And I know that the jury's job in the cases of this sort is to find facts. That's what it is. And the judge is going to instruct them on the law. That's how it is. And the judge is going to determine what's going to be admissible or what's not. And that's just the way the trial's going to go. And I'm trying to let you know that is just to give you advance warning. So when you're in the middle of a trial saying, hey, what's going on here? You just at least have an idea of what's coming. That's all I'm trying to do. And I want to make sure that if you go to trial alone, you're going in with open eyes, understanding that you're at a fairly huge disadvantage. And so, but knowing all that, that's still the avenue you want to take.
You said the jury's job is to decide the facts, but there's no facts to decide because I'm acknowledging all the facts. I'm acknowledging all the facts. I'm not going to challenge them. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about. My issue is the law. And I'm not saying the law is wrong. It's a question of whether the law, this particular law that I'm charged under, applies to me, whether I'm a person within the meaning of the statute.
According to RCW 98.04.110, a person includes various categories, including a natural person. So yes, you're legally considered a person, and the laws do apply to you.
Now, the jurors are taxed to pay legislators to make up laws for their benefit, yet they're not allowed to know what the laws are. Don't you think there's something wrong with that?
Well, I guess my response to that is, I think most people are aware that when you get behind the wheel of an automobile and conduct it in traffic, you need a license. And there are certain things that can happen that can get your license suspended. I think most people know that.
Well, my position is I never had a license, never applied for a license, and I was not engaged in traffic. I was engaged in travel. Traffic is going to be the issue at this trial. And
well, then it'll be up to the jury it'll be jury to determine whether you were in traffic or traveling. That's
excellent.
And the issue that you said, well, I never had a license, so it couldn't be suspended. I've seen people try this before, and I've never seen it work.
License.
So here's what we're going to have. Hang on just a second. Here's what we're going to do today. So right now, trial is set for October 29th and 30th. Jury confirmation is set for October 22nd. You said you had a motion you want to bring. That'll be heard on October 20th. You need to have that filed in writing by October 6th. And the state will have the response filed by October 13th.
Your Honor, if we could please request the defendant's email address so that the response motion can be sent to him as he's not per se.
Did you hear that, Mr. Blatt?
Not really.
They want it because so you're going to file something, and they're going to see it. They should have the opportunity to respond to it, and they want to get their response to you, and they want to do that through email.
That's fine.
All right, Mr. Blatt, I think that's it for today. And then at that particular time, the judge, whether it's me, whether it's one of the other judges here, I don't know.
How many judges work in this court that could be on this case?
4.
4, okay. Can I have their names?
Sure. It's all on the district court website. You can just go look at it.
Okay. Thank you.
And my guess is that judge, whoever hears the motion, is probably going to have a conversation with you again, or at least try to, about the concept of representing yourself and the disadvantage. And again, I know you hate that word. I'm sorry if that offends you in some way, but or going to trial alone without the assistance of an attorney. That's just.
I never expressed hate for any statute or attorney or wording or the.
I don't say that. Again, I'm not suggesting you are. I think that, or if I did use that term, I apologize. I just think that, I'm spending a lot of time with this because I just think you're under some misunderstandings of a lot of real basic points.
He still insists on representing himself, convinced that everyone else are the fools, while he alone possesses a secret knowledge to dodge responsibility for his actions.
And, in terms of we're here in district court, the state of Washington, you want to talk a little constitutional law, state of Washington Constitution sets superior courts of records. It's also in the Constitution that they can set and create such inferior courts as, by statute through the legislature. The legislature has done that. They have established this level of court through Chapter 3 in the Revised Code of Washington, if you want to look there. There's also a mechanism in place where district courts can contract with municipalities to provide court services. All this stuff has been litigated through the Court of Appeals and the Washington State Supreme Court. And again, it's just pretty standard stuff. And I've tried to spend some time explaining it to you. Unfortunately, I don't think I've been very successful. I'm sorry about that. I wish I was more successful, but you can research all that out. And I guess when you talk about one thing I will go back to that I should have said earlier, when you say the jury, you want to argue the law to the jury and shouldn't they know the law and so forth. A lot of that happens in the Court of Appeals and the Washington State Supreme Court. Again, I'll instruct the jury or whoever the judge is, whether it's me or one of my colleagues, will instruct the jury on the law. The jury will decide the facts and then apply the law as I instruct them to it. Now, if I'm wrong about the law and you turn out to be right, all that's handled at the appellate level. You would file an appeal if you're convicted, and then you would, the court at the first superior court would look at it and see if I made a mistake on the law, or you're right on the law, and then it keeps going up all the way to the Court of Appeals, and then eventually to the Washington State Supreme Court, all they may or may not choose to take it. And so that's where the issues of law are decided.
Everything you just said about the evolution of the law is true. However, the Washington State Constitution says that a frequent recurrence to fundamental principles is necessary for a free state. That's what it says. So that means we eventually get so convoluted to oppress citizens of the state that we have to go back to fundamental principles.
Right. And again, I do want to address your last thing, in terms of oppression. Again, let's remember what we're talking about here. And that is your license was suspended and you were alleged to have been driving. I know you have to say, well, you were traveling or whatever. And that's just, again, the only issue is, were you conducting an automobile and was your license suspended? And that's it. That's what this case is all about.
An automobile is different from a motor vehicle, and I believe the statute refers to motor vehicles. Motor vehicles encompass a lot of things. A motor vehicle can be a motorcycle, it can be an automobile, it can be so. And I think that that's generally pretty accepted that an automobile is a motor vehicle. No, I
believe that it is.
A motor vehicle,
unless it runs by. Unless it's the Flintstones where they just run on the ground, then that's not a motor vehicle, but I'm joking. Perhaps I shouldn't be.
A motor vehicle is a specific legal term in commerce. It's a business machine, like a truck, a taxi, or a bus that makes its business on the publicly funded roadways, which it does not have a right to do.
You really need to check the definitions, especially RCW 46.04.670. Which defines a vehicle as any device capable of being moved on a public highway and used to transport or draw people or property. So if you try to argue that you're a living person traveling, not in commerce, in a non-commercial conveyance, what you're actually saying is that you're driving on a public road transporting yourself, which does require a driver's license.
A person
again, in Washington, and again, a motor vehicle includes a car. It does. And again, where do you get your driver's license? You go to the Department of Motor Vehicles, the DMV. That's where you get a driver's license for cars. And so it makes sense that, and again, I don't want to, we're going down a rabbit hole that was really not productive for either one of us, frankly. But, and again, I will just tell you that a motor vehicle includes automobiles within the terms of this statute in this state. It just does. And you can argue
I'll address this in my
otherwise, but you're not going to be successful.
I'll address this in my briefs and my motions, but of course the prosecutor and you will just pretend like you haven't even read it, like it. I've been through this many times.
I'm going to stop you again. I won't speak for the prosecutor, but if it's me, I'll read it. I'll read all of it.
But my experience has been, I'm sorry to say, to accuse you, but my experience has been that judges will just pretend that they haven't read it. They'll say, I've read it and I found it's not correct.
They're not ruling it incorrect because they aren't reading it. They're ruling it incorrect because they are reading it. Just believing something is true doesn't make it align with reality. That wraps up this video. The judge has scheduled a few more motion hearings before the final jury trial. If you liked the video, hit like. If not, hit dislike. And don't forget to comment and subscribe with notifications so you don't miss future content.